So in response to the Supreme Court's recent decision in New York State Rifle and Pistol Association versus Bruin, a second lawsuit has been filed which aims to remove a state's ban on the purchase and possession of suppressors. So let's talk about this. But real quick before we jump into this video, I want to thank the sponsor of this video, which is Kershaw Knives. Kershaw manufactures close to 1 million knives in their US factory every single year. Kershaw produces a broad range of knives to meet everyone's needs. You can get a $20 Walmart knife all the way up to a $200 US made automatic knife. And just recently, Kershaw dropped their new 2023 line, which includes a US made OTF automatic knife. Kershaw always has high quality, durable, and aesthetically pleasing knives. I carry one of their knives every single day for my EDC. And if you're interested in taking a look at Kershaw's products, you can go to their website, and if you use the code 20scholar, you can get 20% off your entire order, plus free shipping on orders of $100 or more, and that actual offer will last until May 1st. So if you're interested, head on over to Kershaw Knives, use that code, and thank you again to Kershaw for sponsoring this video. As I mentioned in the intro, in this video we will be discussing a new case which was just filed to remove a state ban on the purchase and possession of suppressors. This case we'll be talking about in this video is called Anderson versus Rowell. This is a lawsuit filed in the Southern District of Illinois, and it aims to remove a state of Illinois ban on purchase and possession of suppressors. This case is very important because although 42 states allow for the ownership and the purchase of suppressors, there are 8 jurisdictions which don't. Those 8 jurisdictions are California, Delaware, the District of Columbia, Hawaii, Illinois, Massachusetts, New York, New Jersey, and Rhode Island. This case is important because it's going to try to remove the state of Illinois' ban on suppressors, but it also could help to set some sort of precedent or some sort of persuasive evidence to remove the other state bans. This lawsuit uses the Supreme Court's recent ruling in New York State Rifle and Pistol Association versus Bruin to attack this state ban on the purchase of suppressors and also the ownership of suppressors. In Bruin, the Supreme Court issued a 6-3 opinion authored by Justice Thomas, which struck down the state of New York's May issue CCW licensing scheme, and in that decision they found that it was in fact inconsistent with this nation's history and tradition. One of the primary findings of the Bruin decision was that the government bears the burden to prove that their restrictions are based in the history and tradition of this nation. In that opinion, Justice Thomas, writing for the majority, stated that despite the popularity of this 2-step approach, it is one step too many. Step 1 of the predominant framework is broadly consistent with Heller, which demands a test rooted in the Second Amendment's text as informed by history. But Heller and McDonald do not support applying means and scrutiny in the Second Amendment context. In keeping with Heller, we hold that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. To justify its regulation, the government may not simply posit that the regulation promotes an important interest. Rather, the government must demonstrate that the regulation is consistent with this nation's historical tradition of firearms regulation. Only if a firearms regulation is consistent with the nation's historical tradition may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command. So now under the Bruin framework, the state of Illinois and other states which ban the purchase and possession of suppressors must justify those bans using relevant history and tradition which dates back to 1791. This lawsuit aims to finally make a state actually explain how their ban on suppressors is in fact consistent with the text of the Second Amendment. Now let's take a look at some of the arguments which are made in this case. First, the plaintiff states that the suppressors at issue in this case are bearable arms in common use for lawful purposes that law-abiding people possess by the millions. They are therefore neither dangerous nor unusual and cannot be banned. This is actually very important because it is well established now that modern arms are in fact protected by the Second Amendment. It's protected by the text of the Second Amendment, and it's not just muskets and arms that existed back in 1791 which are protected. That's an argument you hear quite often by anti-gunners, but that argument actually has no more legal support. In fact, in the legal world, that type of argument is absolutely irrelevant and it has zero strength. In fact, the Supreme Court reiterated once again in the Bruin decision that modern arms are protected under the text of the Second Amendment. The Supreme Court actually stated that we have already recognized in Heller at least one way in which the Second Amendment's historical fixed meaning applies to new circumstances. Its reference to arms does not apply only to those arms in existence in the 18th century. Just as the First Amendment protects modern forms of communication and the Fourth Amendment applies to modern forms of search, the Second Amendment extends prima facie to all instruments that institute bearable arms, even those that were not in existence at the time of the founding. Thus, even though the Second Amendment's definition of arms is fixed according to its historical understanding, the general definition covers modern instruments that facilitate armed self-defense. So that argument that suppressors are not protected under the text of the Second Amendment, since they didn't exist at the founding era, is 100% irrelevant and has been actually stated as such in multiple Supreme Court decisions. The plaintiffs in this case then go on to state that a suppressor is not dangerous and unusual, and that the mere ownership of suppressors cannot constitute the ownership of a dangerous and unusual item. Instead, these are common arms owned by law-abiding people for lawful purposes, and therefore they are clearly covered by the text of the Second Amendment. The plaintiffs point out that plaintiffs are law-abiding peaceable citizens of Illinois and the United States who wish to possess suppressors banned by Illinois. Defendants enforce the suppressor ban under the color of the state law. Defendants have violated plaintiffs' right to keep and bear arms by precluding them from being able to purchase and possess suppressors because defendants enforce the statute. Defendants' enforcement of the statute and the statute's regulations, customs, policies, and practices related thereto is an infringement and an impermissible burden on plaintiffs' right to keep and bear arms pursuant to the Second and 14th Amendments to the United States Constitution. And therefore the argument is that under Heller and Bruin, a state cannot completely ban the keeping and bearing of suppressors, which is a common arm owned and used for lawful purposes like self-defense. Illinois under the state law bans a device or attachment of any kind designed, used, or intended for use in silencing the report of any firearm. Because of this, Illinois has a complete ban on the purchase, possession, use for hunting, use for self-defense, or any other type of usage of a suppressor in the state of Illinois. So Illinois is completely banning the use and possession of a protected type of arm, which again, even at the federal level, is still legal to purchase and possess as long as you pay your ATF extortion tax under the NFA and as long as you have the registration as well with the ATF. And the argument in this lawsuit is that there is no historical basis to support a state ban on this type of item, and also that even prior to Bruin, the Heller case would clearly point to the fact that a complete ban on a protected arm is in fact unconstitutional. And through this lawsuit, the plaintiffs are seeking for the Illinois ban on suppressors to be found a violation of the Second Amendment, and therefore the court should strike it down. So I was waiting for a case like this to pop up after the Bruin decision. This is the second case in line of all these cases which are challenging the Illinois suppressor ban. We've talked about one of them already on the channel, and that was the Morse case. That was filed by Stephen Stambouli. I always get his last name wrong, and also Alan Beck. Personally, I think Stephen's arguments are a little bit stronger in his case, and it flushed out a little bit more of the context of this type of ban. I think the Morse case is a little bit better written, but I could also be a little bit biased because I know Stephen and I've talked to Stephen. So again, I could be biased, but regardless, these cases are a step in the right direction. And I hope to see more cases like these challenging other state bans on suppressors and other NFA items, because state bans on these items really just doesn't make any sense. And now under Bruin, we have even more support to challenge these types of laws. So this is a case and issue we will definitely be keeping our eyes on. If you have any questions, go ahead and comment down below and I will try to answer the best of my ability. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.